Charles Chauvel.
Thank you, Mr. Speaker. The parts of this legislation that reform the judicial complaints procedure and allow for an increase in the number of associate judges of the High Court were introduced originally by Clayton Cosgrove on 25 June 2008 and read by the House the first time on the 22nd of July that year. As Associate Minister of Justice, Mr. Cosgrove at the time said that they would increase public confidence in the judicial complaints process and ensure that an adequate resourcing level was available to meet the growing workload of the judiciary. In respect of the amendments to judicial complaints procedure, Mr. Cosgrove explained that the amendments were based on the Judicial Conduct Commissioner's own recommendations in his own reports annually to Parliament. And despite some minor changes recommended by the Justice and Electoral Committee and some further changes introduced by supplementary order paper at the committee stages, in essence the legislation that we're now reading a third time and that will become the Judicial Conduct Commissioner and Judicial Conduct Panel, Deputy Commissioner and Disposal of Complaints Amendment Act will do just that. And Sir David Gascoigne, a friend and former colleague of mine, now holds office as Judicial Complaints Commissioner. As I've said on previous occasions, the House can be very confident that he will do an excellent job in that role, and the amendments that we are about to make law will assist him to do so. Sir, as to the raising of the cap on the number of associate judges from 6 to 9, at the time of the first reading of this legislation, Clayton Cosgrove pointed out that this is the first increase in the ceiling since 1991. And he set out very helpfully in his speech the history of this class of judicial officer. He started with the amendment back in 1989 to provide for the appointment of Masters of the High Court, and he noted that since their inception, the jurisdiction of the Masters increased from hearing summary judgment and bankruptcy applications to much more commercial, complex issues such as insolvency proceedings. He canvassed the renaming of the Masters in 2004 to become associate judges, and he recited the fact that at the time they were given permanent tenure of the court. He noted that associate judges have a specialist civil jurisdiction and that they're invaluable in alleviating the workload pressures of judges by undertaking a range of work in the company's law and insolvency area. So, sir, it is clear, I think, that the increase in the statutory cap will enable future associate judge appointments if and when they're required without an unnecessary legislative delay, and this in turn will ensure that adequate resources are available for the growing workload of associate judges, especially in the commencement of the insolvency, given the commencement of the Insolvency Act 2006. Mr. Speaker, Christopher Finlayson conceded during the second reading of this legislation that he and his colleagues had opposed it when it first came before the House, and he used quite strong language to express that opposition. On the judicial complaints issue, he said that the original approach adopted by Labor in this was illustrated by this foolish legislation: set up an office, create procedures, appoint a commissioner, and then bring on the inevitable amendment bill that seeks to appoint a deputy commissioner. The next thing we'll have is a culture of complaint being encouraged and nurtured. There are plenty of litigants out there who, having lost their cases, will personalise them against judges. They're encouraged to do this by this ridiculous regime. We don't see any need for a deputy commissioner. In fact, we don't see any need for a commissioner. This person does not need a deputy because the prospect of conflict of interest is minimal. There's no need to legislate the obvious, such as clauses dealing with the disposal of complaints, and we are therefore opposed to this stupid legislation. Sir, in respect of the proposal to raise the number of maximum associate judges, Mr. Finlayson wondered, quote, whether simply increasing their number at this time masks the real problem with civil litigation, an area of the law that he said the previous Labor government had neglected throughout its term. He referred to a crisis in civil litigation and a system that he said was undermined by costs, increasingly prescriptive processes and delay. He said that a real problem in civil litigation is the vast amount of money being spent on needless discovery of documents, and he said another problem, in my opinion, is the prescriptive case management procedure. He went on to suggest that fundamental reform of the civil justice system is required. He said, "I don't think we need more associate judges. We need fundamental reform. We also need to free judges from the burdens of administration so that they can concentrate on their core job, which is to judge." Sir, as I said, Mr Finlayson acknowledged the change in his position during earlier readings of this legislation. I suppose he could hardly do less, since by then he'd become the sponsor of it. He didn't apologise for the intemperate language that he used in his original speeches, but perhaps that would be too much to hope for. But he went further than reversing his original position and his party's original opposition. He tabled further amendments during the course of the committee stages that provide for another permanent member of the Court of Appeal, 16 new district court judges, and the regularisation of a higher duties allowance to members of the High Court sitting temporarily on the Court of Appeal. Now, sir, none of these amendments went to a select committee despite the significant financial and constitutional issues that they raise, and Mr Finlayson even sought at one stage to have the House deal with them under urgency. Mr Speaker, Labor did decide in the end to support those changes sought by the government when they were asked to do so, although not to have them dealt with under urgency. But in closing, sir, I do want to tell the government and the Attorney-General that, in fact, many members on this side of the House actually have sympathy with the original sentiments that he expressed. There are real issues with the administration of our justice system, and there are real problems that ordinary New Zealanders have with accessing meaningfully justice in our country. Now, many of these matters were ameliorated by Labor in office, but I do agree that more thorough reform is needed. It shouldn't simply be a matter of always increasing the maximum number of judges that can sit in a particular court. As was noted during the committee stage debate, we are now, if we do actually reach the new ceiling in district court numbers, we will have the largest court in Australasia represented by that district court. And it can't simply be the case that we'll continue to add more and more judicial officers to the system without having a look at the fundamental questions that do arise about the operation of that system. I hope that Mr Finlayson will be equal to the challenge of reform of the system, the challenge that he laid out in opposition, and that he doesn't lose his passion for reform now simply because he's sitting on the Treasury benches and being advised by officials. Because if he is to have a place in our history as a significant reformer of the civil justice system, he does need to rise to the challenge of the need for thorough reform of that system. Along the lines, perhaps, sir, of the excellent report of the Law Commission on the structure of the courts, which sadly has sat on the shelves since it was published. But that is an excellent report, sir. It does recommend thorough reform of the system, the creation of a community court at the first level, the rationalisation of the High Court and the Court of Appeal, and the Supreme Court sitting at the apex of the system. And that, sir, is the sort of reform that is actually needed in the system at the moment, not simply the continued addition of more and more judicial officers to the creaky system that currently exists. Sir, if Mr Finlayson is up to that challenge, he'll certainly have support from this side of the House. If he isn't, sir, then certainly the next Labor government will be looking to enact those sort of reforms. Thank you, sir.